During a House Judiciary Committee hearing in early 2026, Representative Jamie Raskin questioned Attorney General Pam Bondi about the Domestic Emoluments Clause, President Trump's lawsuits against the federal government, and the Department of Justice's handling of Epstein survivors' personal information. The exchange quickly devolved into a confrontation about committee rules and procedural decorum. Raskin's central question concerned whether it would violate the Constitution's Domestic Emoluments Clause for Trump, who has sued the federal government for $10 billion over leaked tax returns to settle that case with his own Justice Department. Raskin then pivoted to comparing Trump's privacy violation claims to what he characterized as far worse privacy violations against Epstein survivors whose names, phone numbers, and addresses were released by DOJ despite federal protections. Bondi declined to discuss pending litigation and repeatedly went off topic during Raskin's questioning, prompting multiple attempts by Raskin to reclaim his time and explain committee rules. The exchange ended with the chairman defending Bondi's performance and Raskin objecting that she was embarrassing the committee. Watch how Raskin opened his questioning.
And thank you, Mr. Chairman. I want to start by saying I appreciate what you said, Attorney General Bondi, and you said it to me personally, that you take the personal security of every member of Congress seriously and that people can contact you about that. And in these times, that's a very serious matter. So I thank you for that. Article 2, Section 1, Clause 7 of the Constitution is the Domestic Emoluments Clause. And it says that the president is limited to his salary in office and cannot receive any other money from the federal government while he's in office. It cannot be increased by $1. This president is the first president in U.S. history who has repeatedly sued the federal government for $230 million for the judicial search warrant at Mar-a-Lago, which was perfectly lawful and was never struck down. But now he's suing the IRS for $10 billion. He's suing the IRS for $10 billion, which I think is around 80% of its annual budget, because his tax returns were leaked. And they were illegally leaked by a private contractor who actually is in prison now, Charles Littlejohn. But he wants $10 billion. Now, but I want to ask you the question of whether you think it would violate the Domestic Emoluments Clause for you to settle that $10 billion case or any of the other claims that the president has made against the government. He himself has remarked, it's interesting because I'm the one that makes the deal, right? And he says, I kind of have to work it out with myself. Do you think it would violate the Domestic Emoluments Clause for the president to work out a deal from people who are his subordinates under his unitary executive theory to get money in one of these cases?
I'm not going to discuss pending litigation.
Okay, so theoretically you're saying because his privacy rights were violated in that tax case, and they were. I'm with the president on that. I mean, his Mar-a-Lago thing is ridiculous, but there's no doubt that his tax returns, despite the fact that he promised to release them, despite the fact that every other president released the tax returns, he suffered embarrassment when it showed that he hadn't paid taxes for several years, and he had a right for that not to happen. Now, I want to turn back to the Epstein survivors, because President Trump may have been a little bit embarrassed by the release of those tax returns. How much do you think the claims of these survivors are worth? As the good congressman from Kentucky just pointed out, there were lots of survivors who had decided, for reasons of their own, never to release their names. That determination was represented to people in Congress, and we built it into our federal law that their names could not be released, and yet you published their names, their phone numbers, their addresses, personally identifying information. If Donald Trump can get $10 billion theoretically from the Department of Justice, how much should these people get for a far worse violation of their privacy rights and a far greater danger established to them in their lives?
Do you even know who Chase Mulligan is? You're so obsessed with, you
Okay,
don't, do you?
I'm going to teach you the rules again.
Face.
You're the Attorney General of the United States. We have rules here.
You're obsessed with him.
You're the Attorney General of the United States.
You're obsessed with Donald Trump. You have Trump derangement syndrome.
Mr. Chairman, I'd like my time
Mulligan will be
restored. I'd like my time restored.
In your district. In your district, and you don't even know about it, about keeping children safe from online predators.
Time belongs to the gentleman from Maryland. The gentleman can proceed.
Representative Raskin's opening invoked the Domestic Emoluments Clause. Article 2, Section 1, Clause 7 of the Constitution, which states, the President shall, at stated times, receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. The clause's purpose is to prevent the president from using the office to enrich himself through federal funds beyond the constitutionally fixed salary. Raskin's question concerned whether settling a lawsuit against the federal government while president would constitute receiving any other emolument from the United States. Raskin cited two specific Trump lawsuits against the federal government: a $230 million suit related to the FBI's search of Mar-a-Lago in August 2022, and a $10 billion suit against the IRS for the leak of his tax returns. The Mar-a-Lago search was conducted pursuant to a warrant approved by a federal magistrate judge after a finding of probable cause. The search has not been ruled unlawful by any court. The tax return leak Raskin referenced involved Charles Littlejohn, a former IRS contractor who pleaded guilty in 2023 to unauthorized disclosure of tax returns and was sentenced to 5 years in prison, the maximum sentence for the offense. Littlejohn leaked Trump's tax returns to news organizations, resulting in public reporting that Trump paid minimal or no federal income taxes in certain years. Trump's lawsuit seeking $10 billion in damages for the privacy violation represents, according to Raskin's calculation, approximately 80% of the IRS's annual budget. The IRS's fiscal year 2024 budget was approximately $12.3 billion. A $10 billion settlement would indeed represent a substantial portion of the agency's resources. Raskin's question whether it would violate the Emoluments Clause for Trump to settle such a case with his own Justice Department raises a constitutional question that has not been definitively resolved by courts. Trump's own statement that I'm the one that makes the deal and I kind of have to work it out with myself acknowledges the unusual situation of a president negotiating with executive branch agencies under his authority. A G. Bondi response, I'm not going to discuss pending litigation, is a standard practice for attorneys general regarding active cases. However, Raskin's question was framed as theoretical and constitutional rather than seeking details about litigation strategy. Raskin then pivoted to Epstein survivors, comparing Trump's embarrassment over tax return disclosures to what he characterized as far more serious privacy violations. According to Raskin, Congress enacted federal law protecting Epstein survivors' identities, yet DOJ released their names, their phone numbers, their addresses, personally identifying information. The Epstein Files Transparency Act and related legislation included provisions requiring victim identity protection. Multiple members of Congress, including Representative Jamie Raskin and others, have stated that DOJ violated these protections by releasing unredacted or insufficiently redacted documents. Raskin's comparison, if Trump can theoretically get $10 billion for privacy violations, what should Epstein survivors get for worse violations and greater danger, represents a rhetorical argument about proportionality and DOJ priorities rather than a legal calculation of damages. The exchange broke down when Bondi mentioned Chase Mulligan and accused Raskin of Trump derangement syndrome. Watch how Raskin attempted to restore order and explain committee rules.
And I want the whole country to look at this, because this is the Attorney General of the United States, whose job is law enforcement. We've never had a witness who has misunderstood our rules and been unable to conform his or her conduct to our rules before. We have only 5 minutes, And so we use our time to ask you specific questions.
How long are you giving me to
Excuse
answer?
me, I'm not yielding to you right now. I'd like that second restored too. So, Ms. Bondi, the way it works is we ask you a question and you answer it. And if you go off on a wild goose chase, another tangent, you start reading statistics or you start talking about stuff going on in our district. And by the way, I invite you to my district. Come to my district, but that's not what we're here to do today. Okay, so, and you do that, then we're allowed to say we reclaim our time. At that point, you have to be quiet. You have no choice. You have to be quiet. So I hope you understand the rule at this point. Now, here's what I want to ask you. You're in law enforcement. We've seen all kinds of evidence of crimes. And when we go over to the Department of Justice for the 4 computers for every member of Congress, we see more evidence of crimes. Will you create a joint task force of the Department of Justice and governors and state attorney generals and district attorneys across the country to investigate the crimes that have taken place against these victims and more than 1,000 like them? The DOJ is not doing its job. Will you create a task force with state and local law enforcement to make that happen?
Gentlelady can respond if she wants to.
Thank you, Chairman. He called Chase Mulligan a wild goose chase and didn't even know who he was. He is a defendant in your own district who preyed on girls.
Mr. Chairman.
Well, you know what? If he were part of the Epstein investigation, you wouldn't do anything about it.
Online chat rooms and committed sextortion. Yet he didn't even know in your tiny little district who he was.
Mr. Chairman, she's embarrassing you.
He's about to be
This is your committee, and she is embarrassing
Shame
you.
on you.
The time of the gentleman has expired. I would remind the committee that last Congress, Secretary Mayorkas was here numerous times, and he wouldn't answer our questions, even when we sent them to him ahead of time in writing. So that's what we've had to deal with. I think the Attorney General is doing just fine. We have votes shortly.
Representative Raskin's attempt to explain committee procedures reflects standard House rules for questioning witnesses during oversight hearings. Members typically receive 5 minutes for questioning, during which they can ask questions and reclaim their time if witnesses go off topic or provide non-responsive answers. Raskin's statement that we've never had a witness who has misunderstood our rules and been unable to conform his or her conduct to our rules before characterizes Bondi behavior as unprecedented. While witnesses frequently give evasive or lengthy answers, direct confrontation and refusal to yield when time is reclaimed is less common in congressional hearings. The substantive question Raskin posed, whether Bondi would create a joint task force of the Department of Justice and governors and state attorney generals and district attorneys across the country to investigate the crimes that have taken place against these victims, represents a specific policy proposal for addressing crimes documented in the Epstein Files. Raskin's statement that members of Congress have access to 4 computers at DOJ containing evidence relates to the arrangement whereby members can view unredacted Epstein files at the Department of Justice. Multiple representatives have stated they found evidence of crimes in these files that have not been prosecuted. Bondi response about Chase Mulligan, identifying him as a defendant in your own district who preyed on girls, appears to be an attempt to deflect from Raskin's question by accusing him of ignorance about local crimes. Chase Mulligan is not a publicly known figure in connection with the Epstein investigation based on available reporting. Raskin's characterization of this as a wild goose chase and his statement that Bondi is embarrassing the committee and the chairman reflects his view that her responses were non-responsive and violated hearing decorum. Chairman Jim Jordan's defense of Bondi, comparing her favorably to former DHS Secretary Alejandro Mayorkas, who Jordan stated wouldn't answer our questions even when we sent them to him ahead of time in writing, represents the partisan divide in how Bondi testimony was received. The hearing exchange devolved from substantive constitutional and policy questions into a confrontation about procedural rules and personal accusations. Raskin's core questions, whether Trump settling lawsuits against his own government violates the Emoluments Clause, why Epstein survivors whose privacy was violated don't receive similar consideration, and whether DOJ will create a task force to investigate crimes in the Epstein files, went largely unanswered. Bondi declined to discuss pending litigation regarding the emoluments question, did not address the comparison between Trump's and survivors' privacy violations, and did not respond to the task force proposal before the exchange broke down. What the exchange revealed is the difficulty of conducting oversight when witnesses and members have fundamentally different views about the scope of appropriate questioning and the boundaries of responsive answers. Whether Bondi approach, declining to discuss certain topics and raising unrelated issues, constitutes legitimate witness conduct or obstruction of congressional oversight, represents a partisan disagreement that the hearing did not resolve. These hearings are public record, but they're often buried in hours of footage most people never see. We break them down, provide context, cite sources, and let you decide what it means. If you believe the public should have access to detailed oversight coverage, not sound bites, but full exchanges, subscribe to this channel and hit the like button. Transparency requires an audience. Be part of it.